invention process. A provisional patent, like Marcy's mentioning, will give you the right for 12 months to say that your product is patent pending. Go out there, engage the market, think about the different options that you're going to possibly get to, either to manufacture it or to license it. At that point, there is nobody that actually can see your intellectual property of what you filed. The patent office doesn't even look at your provisional patent. It's basically it's broad, I should say. It doesn't include claims. Like if you go on Google Patents and you see a fully issued patent, that's not what a provisional patent is. It's just the basics, the broad scope of what your invention is that'll cover it. And later on, when it converts into a utility patent, otherwise known as a non-provisional patent, that's when you or your patent agent or patent attorney, whoever's doing it, can really put the meat into it and protect it. And that's what gets presented in front of the examiners at the patent office. There's a question that came in: how long do patents last? A utility patent, like we're talking about, otherwise known as a non-provisional patent, they last for 20 years. And then once it expires, it's public domain. A design patent, which is ornamental, lasts 14 years. And that provisional patent, like Marcy mentioned, which is a great way, in my opinion also, to really gauge the market and see what kind of opportunity you have and feel protected to let people know and put them on notice that it's patent pending, and you should just consider that it's my concept and you can't rip it off.
Yeah. And the other thing, I think, in starting out, a lot of inventors have a great name for their products. Like sometimes the name even comes before the product, something that's catchy that they love. And I'm a really big believer in trademarks. And a trademark is an inexpensive way, not an inexpensive way to protect the entire product, but it's not that expensive. It's not as big of a commitment as a patent is. And sometimes trademarks can be more valuable than a patent can be. Every situation is different, of course. But sometimes the name, if you can build brand loyalty behind it, can be just as valuable, if not more valuable, than a patent itself.
Okay.
So I think at that point, a trademark is something to consider as well.
Well, let's give a good example, Marcy. So there was this product that came out several years ago, and we had the All-Star Marketing, which is was doing it. You ever hear of the product called the Snuggie? Well, the Snuggie, at the point that it launched, had no intellectual property for a patent. Okay, it was somebody came out with a blanket with sleeves long before I think I was even born, and eventually it expired, and then came a great name, the Snuggie, and then all of a sudden it got into the market, and that was for a trademark of a name, Snuggie. And that's why you see Slanket and this one and that one. There's all these different products similar because they have the right to under a different name. And that's what a trademark is. A trademark, sometimes if you're involved with a product and it may not be patentable or it cannot be issued a patent because it's already public domain, you come up with a good name. But that doesn't mean that somebody else can't do that product and come up with a good name. So that's what a trademark is. Back in the day, I had a bunch of trademarks, and I licensed a line of clothing with trademarks, and that was very interesting. I mean, it was a T-shirt with different designs on it, and the designs, each one of them had a trademark. So it's interesting, and you can license trademarks. Hello Kitty, you see T-shirts, let's say, with Coca-Cola on it. The T-shirt company licensed Coca-Cola's name. That's kind of like a reverse license. There's other people, if you have a license and you can go out and you could say, you know what, I came up with a great name for this type of product, and they would kind of private label it under that name. There's a lot of different things to do, but like you're saying, Marcy, it always that's first couple steps of coming up with a name. I totally agree. It makes you really own it and put your name on it and kind of just makes it real, right?
It does. And to give you another example of trademark situation, I'm in that situation right now where I have a product. To your point, the actual product itself is not patentable. I'm working with one of the top-tier DRTV companies right now, and we're in negotiations for this product. And the whole reason they want the product, not the whole reason, they like the product also, but they wouldn't take the product if it didn't have the name that I trademarked. So for them right now, it really is about the name. The name is, when I can finally release all this information, it'll make sense to you, that the name is what really makes the product. And you know whatever your particular invention is and how important that name is. And if it is important, I say file that trademark right away.
True.
And it's so inexpensive to do. I mean, you can do it through LegalZoom now. They have packages that start at $169 plus the government filing fee. And I'm not saying that's definitely the way to go, but if you're inventing on a budget, that's one way to go. That's definitely an option to look at. And I've done a couple of trademarks through LegalZoom, and I've been very happy with it.
Yep, LegalZoom is great. They've been a guest on our show. You could take a look at one of the past shows and or put in the search LegalZoom on our website, and you'll be able to listen to how to work a trademark with them. The other thing also is you could go to uspto.gov website and click on Search Trademarks and take a look and see the name that you put in, if it's under a certain category or class of goods, and you could take a look and see if your class of goods is available, and you could file it. And when you first put in for a registration, it starts off as a TM. The application, I should say, it starts off as a TM. So when you look at a product and you see a TM on it, they just recently filed, or they filed a trademark, or they didn't file a trademark at all, they still have the right to put a TM on it to put people on notice that it's their name. Eventually, when you file the trademark and then you show the patent office, the United States Patent and Trademark Office, that you've actually used it in commerce, then they issue you what's called a registration mark. So when you look at a product, take a look at the difference between a TM and then if it's registered and being used in commerce and registered with the USPTO, you'll see an R next to the name, which is very interesting. So that's a great point, Marcy. The names are great, putting a trademark to it. Obviously, you want to be able to bring your product to a certain point before you start spending money. It's always also good to try to get a domain name. You can go on GoDaddy, and for $10 you have the domain name also to match.
Absolutely. I just did that for a couple products, actually. And I think to that point, I'm going to GoDaddy. You can buy all the different variations of that name as well. And that's for very little money. That's money well spent, whether it's .net, .com, does it have a hyphen in it? But, to try to really store up that name if you think it's going to be a valuable part of your invention is I think a good way to spend your money.
Sure.
I have to say one other thing on the trademark versus patent issue. One of the other things I really like about trademarks is that you can protect yourself with a trademark quickly and inexpensively, whereas with a patent, sometimes you think patents are only as valuable as the money that you have behind you to defend them should somebody infringe on your patent. And so I can give you an example. My coach on Homemade Millionaire, she invented what's called the Tingler. I don't know if you remember that. It was sort of made out of coat hangers and with a handle, and it tickled the top of your head.
Yes, she was she was actually a guest on our show as well.
Oh, you're kidding. I didn't know that. Yep. Oh, I love Wendy.
Yep.
So anyway, should she talk about that?
Absolutely. Wendy Robbins was on our show last year.
Yeah, so somebody infringed on her patent, and it ended up costing her something like $750,000 to defend it. And she ended up winning, but that was a real eye-opener for me, realizing you're not truly protected when you get the patent. I mean, you're only protected for as much as you can afford to defend that patent. So I thought that was interesting. Whereas with trademarks, if somebody infringes, you can send a cease and desist letter and stop them from having a product out there in commerce immediately. So, there's different ways to look at it, but point being that definitely explore all those options before you spend a ton of money in any one of those categories.
Sure. And Marcy, I just want to clear a few things. There's the chat feature, which is from our radio show. If you're listening live right now, go ahead. Cliff, you're active. Alex, you're active. I see emails coming in also. Brian@gotinvention.com from some of our loyal listeners that are always listening to the show live on Thursdays. Couple things, Marcy. Trademarks do not protect your idea. It's just the name. So Marcy chooses to when she comes up with the idea to possibly trademark the name right away and see if it's out there through different means. Other people might want to trademark it when you actually have a product that you feel comfortable with and come up with a name. If you're looking to license it, you have a name to it and you present it with your intellectual property of your, let's say, your patent or your patent pending. They may change the name, so it may not necessarily be worth it to do a trademark. But a trademark's only a few $100s, so it's not that expensive. But everything adds up, and I know that quite a bit of inventors are consciously aware of what they spend. Cliff, you have a question. Intent and intent to use for a trademark. So when you file, you can go ahead right now and file a name for your your brand or your product, let's say, and you don't necessarily have to have it being used in commerce today. You can have it so you can just kind of protect the name right now. It's like buying a domain name and not having a website up right now for possibly a future website that you may want to do with that domain name. Once you do use it in commerce, you go back to the website for the USPTO. You have one of your representatives, intellectual property attorney or whoever's doing that, file an intent to actually being used in commerce, and that's again when you receive your registration mark. All right, let's continue to move on, Marcy. So we came up with searching and working on coming up with a name and bringing it to a point. So tell me, how do you make it real? What do you do, Marcy? How do you make it so you can really bring your idea to life?
The next step for me, and I touched on it before, but is the prototyping. You know, you have to know, does this idea that you have really work? And so putting together, as I mentioned before, putting together a prototype that's really inexpensive. You don't have to race out and, hire a product development company to do a prototype in the beginning. So putting something together at home. What I did with the product that I won, Homemade Millionaire, with Style and Go, I actually went to a local college and went to the woodworking department and had them build me a prototype, and they did it for free. They didn't want any money for it. I ended up paying them a little bit of money, but they like the experience of being able to do that. So there's options of how to get something made without necessarily spending a lot of money. The other thing that I do pretty much all the time now is I work with a company out of San Diego that's called VizSource, and they create photorealistic 3D renderings for me of my ideas. So when I have an idea, what I do is I put together a sketch, scan it, get it over to them. I'll go on the internet and I'll find different pictures of things that represent what I'm wanting it to look like. So it's sort of a matter of cutting and pasting, like I like this color, I like this shape, I want to show it in this type of a setting. And within 5 days, they turn around to me a photorealistic rendering. So it actually looks like my product exists.
Okay, it's a 2D drawing. It's not a 3D, though.
Well, it's called 3D rendering.
Okay.
They are called 3D because it looks like it exists. It's not and that's the technical term for it. It is actually 3D.
Okay.
But I know what you're saying. It's not a physical prototype. No, it's a photograph.
No. I'm talking about files. When it's a 2D drawing of a file, it's something that you could see how it could potentially look. If you want to take that concept or that look of what they kind of rendered together and give it to a company or a machine to actually make a physical prototype, then you need 3D drawing, 3D files, otherwise known as CAD drawings. So they can take that and they can convert it into a CAD drawing to be able to make a prototype.
Correct. But for the purposes of why I was bringing that up is that costs all of about $495, $500 in that range. And I have been able to take just those photographs of the product that I envision in my mind, and I've been able to take them to HSN, to DRTV companies, and actually get the green light for these products based on just those photos. Now, that's not going to happen every time. It depends on the product. It depends, do they need to feel it, touch it, move it around in order to make a decision on it? Or can you convey the functionality of the product, and clearly what the product looks like is already in the photograph? So for me, I've had tremendous luck doing it this way and have saved so much money in the process.
Sure. It's also once you establish a relationship, it gets a bit easier. But for the most